Well, ARPA supporters, I am so pleased to be able to come to you with my friend and former colleague, John Sikkema, a lawyer with the Acacia Group, because we have really good news, exceptional news, coming out of the Supreme Court of Canada this morning. And we're so delighted to be able to discuss together the decision in the AGA case. So this is a case that we started telling you about all the way back in February of last year. The Ontario Court of Appeal had released a decision that really concerned us, and ARPA Canada was quite involved, both behind the scenes and at the forefront of our own intervention in trying to see this case get to the Supreme Court and in order to overturn a really bad decision from the Ontario Court of Appeal. So I'm so thankful because John, who used to be a colleague of mine, last year he was legal counsel with ARPA Canada, and he took the lead on this file on ARPA Canada's intervention in the Supreme Court of Canada, and he's here to discuss this really encouraging decision. So, John, thanks so much for coming in. Thanks so much for being here to talk about this case with us. And can you, first of all, just give us a snapshot of the case? How did it get to the Supreme Court, and why is it so important for our viewers?
Sure. So, the case started, it's the Ethiopian Orthodox Church of Canada, and the church had a group of lay members on a committee, and the committee was looking into what they considered a heretical movement in the church. I think in their view was overly Protestant in the Ethiopian Orthodox context, and they wanted the church to implement their recommendations. And they thought that the committee had certain rules, a certain mandate, and they didn't feel that the church authorities, the bishop in particular, was following their recommendations, and they thought he had agreed to follow their recommendations. And anyway, this all leads to the bishop saying, you need to let this go, you need to stop pressing this issue, it's causing a lot of division and unnecessary strife in the church. Mm-hmm. And it leads to their expulsion from the church, and so they take the church to court. The named parties include the bishop, and they say, look, we were not validly expelled. They argued to the court. They also asked the court actually to make the church implement their committee's recommendations, which actually included taking steps against certain other church members. Right. So they basically want the court to say, we shouldn't be expelled. The church should listen to us, and the church should take certain steps against other members. So this goes to court. The lower court judge says, I can't do this. There's the Wall decision. It says, I don't see a real legal issue here. It's obviously internal church issues and theological issues and so on. I got to let this case go. Very short decision. Before you kind of get into a big messy trial, that case was done. But the expelled members appealed, and the Court of Appeal looks at it, and they start looking at the church documents, the church constitution. The church also has something called the bylaws for the church in the diaspora, outside of Ethiopia. And they see language in there about rights and obligations of members. They see some things about procedure for discipline. And they say, well, this looks like legal language. It looks like there's some legal rights here. And then they also see that in the church membership application form, there's a place where people can fill out how much they will tithe per month. Okay. And the court says, well, that looks like consideration, which in a contract means if I offer you a service or my car and you say, I'll pay you X for it, and we agree to that, and you have a contract, a civilly binding contract. So the court says, this looks kind of like a contract. We'll take the case. Some legal issues here, there's a contract, and we'll adjudicate whether you were validly expelled on that basis. That was a unanimous Ontario Court of Appeal. Right. And that's the decision that we came across. Tabitha flagged it, and then we started discussing it in the office, and that led to a real, I think, we realized that this needs to be appealed. So that's how this kind of started.
Cool. Yeah, and so we've got a case here where three judges, a unanimous Court of Appeal decision says, look, a church expels or excommunicates, to use common language from the Reformed tradition, excommunicates some members for causing division around a heretical movement. So there's a question of doctrine and expulsion. And the Court of Appeal says, yeah, we're competent to be able to determine whether or not that happened appropriately. And I think you, our viewers, would see that and hear like, oh, that would be concerning to our churches if suddenly a secular court would start reviewing those kinds of questions. So it goes to the Supreme Court of Canada. ARPA Canada file, there's a number of different interveners, including ARPA Canada. We file 10 pages, I think it was, of written legal argument. And then I remember watching you arguing in the Supreme Court of Canada. You had 5 minutes to make a particular oral argument that was done via Zoom in December. And then now today, this morning, a decision comes out, and it's not just any decision in the sense that it's 5 say this, 3 say this, and 2 say this. It's a unanimous decision, which is really encouraging because the whole court is saying with one voice, this is what the law is when it comes to reviewing these kinds of internal church matters. And can you give us a snapshot? Is it what makes it so good?
Yeah. So, well, for one thing, it's unanimous again, as with Wall. Mm-hmm. Justice Rowe wrote this one as he wrote Wall. And the court clarifies some things that I think it spoke to in the Wall decision, mm-hmm. But it specifically looks at the contract issue, mm-hmm. And explains that I think one of the most important things is it says there may be religious obligations set out even in written religious documents, right. Even if it does use the terms of rights or obligations. Mm-hmm. And these may be religious and spiritual rights and obligations that are not intended to be civil rights or obligations or civilly enforceable rights and obligations. And that kind of distinction was obviously the major focus of our submissions. Mm-hmm. Certainly others touched on it as well. And that was very clearly articulated in the decision that you can't assume that religious rights and obligations, religious documents, church order, that kind of thing, in this case, canon law and bylaws in a church constitution, create legally binding rights that you can take to court and sue your church over, or that the church can sue you for not abiding by internal church rules or church doctrine.
Yeah, they say or Justice Rowe writes in paragraph 41, he says, in the religious context, even the use of concepts such as authority and duty need not reflect an intention to create legal relations. The parties may be speaking of religious obligations rather than legal obligations. I think that's a really important distinction. So in a blog that you wrote about this case back in February of last year, so long before the decision was even heard or the case was even heard by the Supreme Court of Canada, you make reference to the difference between a semantic versus a substantive difference between the meaning of words like constitution and bylaws and even the word law. What is the difference between law or bylaws or constitution in the church's use of the words versus within the courts? Right. Why is it important?
Yeah, so the difference is kind of the semantic versus the substantive confusion is, I think, what led to this case being wrongly decided at the Ontario Court of Appeal. So in the Wall case, the court looked at the Organized to Do Jehovah's Will Handbook, the Jehovah's Witnesses written governing document. Right. And in that case, the Supreme Court says where an organization has a written constitution and bylaws, those may be contractual. They may be intended to be civilly enforceable. That was kind of misread in this case as, if you've got a constitution, if you've got bylaws, you've got a legal case. Right. And so in this case, the church actually calls its documents constitution and bylaws. Right. But again, the question is that so different from the Organized to Do Jehovah's Will Handbook? Is it so different from, let's say, a church order or a code of canon law? These things go by different terms. Right. But the key thing, I think, to recognize is that churches can have an internal law, internal procedures. We can use even legal terminology for it. Right. And we can say that doesn't make it something that the courts have supervision over, which maybe to the average person, they think, well, if it's law, then the law courts must sit on top of that. And I think, obviously, from a reform perspective, to say sphere sovereignty not only involves different types of authorities, it can involve different types of law. So it doesn't mean that the church is governed without law.
That's right.
It should be governed lawfully. Yeah. but then the question is, who is interpreting and applying
Right.
that law? Which body or individuals are responsible for doing that, and are they supervised by? We don't take a hierarchical view that they're supervised by the civil courts. We
Right.
say they're separate.
Yeah.
They're separate types of authority and separate types of law.
Right. So like a church order, for example, the church order of the Canadian Reformed Churches or the church order of the United Reformed Churches, for example, like that would be comparable to the constitution of this Ethiopian church. And just because it's a constitution of type, a type of constitution of a church, doesn't mean the courts get to interpret it and apply it. And just because there's language like, well, you can appeal to a classis or you can appeal to a general synod, though that legal language of appeal, again, doesn't mean that there's necessarily any recourse to a civil judge, like okay.
Exactly. Yeah.
So, what does the court do with a more worldview question? So, one of the things that you and I have talked about as well when it comes down to the church, I remember you put a quote in the Factum, our Factum from Doyewerd, a Reformed constitutional scholar and philosopher, about how the church is not just any normal average voluntary association. There's something special about the church. Does the court here, the Supreme Court of Canada, wrestle with that question at all, or is there a bit of a lacking appreciation for how the church is distinct from other voluntary associations?
I think there may be somewhat of a kind of homogenizing of non-state institutions or organizations, where the court looks at this and says, look, there's lots of kinds of voluntary associations. Some may write their rules in a way or communicate things in a way that shows they intend to be civilly bound in court. They give an example of a yacht club where they're going to race yachts, and they say if you damage someone's yacht, you're going to have to pay for it, and everyone's supposed to sign this thing
Right.
before they do. So the question is, well, is that a gentleman's agreement? Is it just what friends are saying? You know, if you you wreck my thing, you got to, or is it meant? And they said in that case it was kind of formal enough, and in the context, it seems like they wanted to be civilly bound
Right.
to pay if they crash their yacht into someone else's, right? The court basically says it does depend on context. So maybe the difference between churches and other kinds of associations is implicit in that the court is saying, well, in the religious context, we have to recognize that there can be more formal language. There can be language of rights that isn't meant to be civilly enforceable, but there isn't. If there is a recognition of the uniqueness of the church, it's implicit at best. The court does talk about all of these types of things: a yacht club, or a tennis club, or a
Stamp collectors club, I think.
right, or a church. As basically, they're kind of the same thing.
Right.
People come together for there's actually a line in here where it says for a common purpose. It might be a common religious purpose, a common spiritual purpose. We say together, we want to get together with a group of people to worship God, to study the Bible, and this entity is defined by that, by the purpose we all have in our heads for
Right.
getting together.
Right.
And then the question for the court is, how do you manifest that, what you have in your head? Do you
Right.
write it down? Do you how formal is it?
Right.
And what would the outsider looking in say you want to do with that? And if you want to be able to take it to court. Whereas Doyewerd, and in our earlier Wall Factum, we also quoted Bonhoeffer to the same effect, to say that the church is not a voluntary association. It's not a kind of meeting of individual wills, and therefore what the church is defined by whatever people want it to be who are
Right.
in the church.
Right.
We would say it's fundamentally different than that. It's based on the Word of God. It's based on certain offices and tasks defined in the Word of God. And that's very important to recognize, I think, legally as well. And it's a little bit there in Wall and in AGA, but it's only implicit,
Yeah.
right? They say certain issues, if it's a religious issue, we probably shouldn't touch it. If it's a religious context, it's probably not a contract the way the yacht club might be.
Right.
But it's obviously not so clearly articulated as in certain Christian thinkers. Maybe
Yeah.
we shouldn't expect that, but
Yeah. There's just a hint of it in paragraph 51. He writes, Justice Rowe writes, more importantly, he says, becoming a member of a religious, and he puts religious in italics, a religious voluntary association does not evince an objective intention to enter into a legal contract enforceable by the court. So there's a hint there. It's like, look, the religious voluntary association, there's something particularly special about that, where that gathering together, they're not looking to try to enter into some sort of contract that their membership in that group is going to be governed by the courts. But yeah, it's definitely not explicit, and not in the way we would see it in Kuyper's writing. It was about sphere sovereignty, for example, or Doyawerd or anyone else. So are you saying, or would we be saying as Reformed believers that, look, when there's a matter happening within a dispute within a church, that the courts can never be involved, that the courts can never be the ones to sort out a dispute? Like, would you have an example of where it's like, no, actually, we, even as Reformed believers, we say, no, it's absolutely legitimate for a civil court to sort out this matter?
Yeah, I think so. As the judgment talks about it, the question is there a civil right? And I guess what constitutes a civil right or a legal right? It kind of depends on the context. If you've got, let's say, a church member who's always been the guy to do, I don't know, the roofing on the church and things like that, and he's kind of the go-to guy, but you still pay him for the work he does.
Right.
And now he has, I don't know, by his behavior caused division in the church, or he's done something immoral or what have you, and the church hasn't paid him yet for the roofing. And you
Right.
say, you've been so destructive to the life of this congregation, we want you out, and we're not going to pay you for it. Well, if he's being disciplined by the church, we would say that's a matter of spiritual authority. There's not a supervisory role for the civil court to have there. But if you say, are we going to keep hiring this guy to do the roofing? Are we going to pay him for the roofing? There's a legal element to that, even if it intersects somewhat with how the church is dealing with him as a member, and there's a spiritual aspect to that the court maybe leaves that alone. But the court might say, look, objectively, the guy is spending his time and working on something that ordinarily he'd be compensated for. You got to pay him.
Yeah.
And that's not a judge interfering in the internal life of the church in the way that this case might have led to if it had gone the other way. Right.
Yeah, and of course we remember Paul's warning about trying to sort things out amongst ourselves as brothers before bringing something to a civil magistrate. But certainly it's legitimate if we can't sort that out, where there's that legal right at stake, whether that's in true contract or a property right or something like that can be sorted out by a secular court. Okay, so is there a warning or any sort of a practical application of a decision like this for Reformed churches moving forward? Is there something that arises in this case where you're reading it as a lawyer who advises on churches? I mean, the Acacia Group specializes, I think, in advising churches in particular around legal issues. As you read that, as a professional lawyer, you're like, I think Reformed churches in particular should keep this in mind moving forward. Perhaps they're looking to institute a new church and how they set up that church. Are there principles here or red flags even in this decision where Reformed churches would do well to be cautious around this or that?
Yeah, so one thing we haven't talked about yet is, and I think it was less important than the whole contract issue that the Ontario Court of Appeal latched onto. The Ontario Court of Appeal also pointed out that this church is incorporated, unlike the church in the Wall case, the congregation in the Wall case. There was no corporation. And so, of course, this year, well, there is a corporation, so that's a difference. So maybe this case should go differently. And the Supreme Court deals with that pretty quickly. In paragraph 5, the Supreme Court says, the congregation, in this case, is an unincorporated association. Okay. Right? So that is the members of the Ethiopian Orthodox Church. They don't have a legal status. They're not members of a corporation. And quite a few churches are set up where people are members of a corporation or members of a society under the Societies Act if you're out on the West Coast. And that is an important distinction. The court says here, this church is incorporated, but it's the church leadership only who control the corporation, and the corporation is, for the sake of its purpose, is to promote the Ethiopian Orthodox faith and then to deal with matters of property and so on. So the corporation holds the property. The members in the congregation, that's not incorporated, right? And so if you incorporate a congregation and the members, that could, on the threshold jurisdiction issue, can the court look at this? Of course, the court is going to say, we can look at your articles of incorporation. I mean, you filed that with the Ontario government. Right. And so it may have religious language in there, but there's that threshold issue that's a bit easier to get across. You still might be able to say, yeah, but in the issue is spiritual, even though it's covered in our corporate bylaws and so on, the court may still may not be suited to deal with a specific issue. So it's not to say that incorporating per se is wrong, but churches specifically that have incorporated in that where their members are corporate members,
Right.
They may want to consider carefully how that's worded and and maybe even whether a different structure, if new churches are setting up, what structure is the best structure to avoid unnecessary litigation. Now we've got 2 Supreme Court judgments in a row basically saying church membership on its own, especially if you're not a corporate member, the courts can't touch it.
Right.
So hopefully that should avoid unnecessary litigation. If someone does try to take you to court, it can be dismissed fairly quickly.
Yeah, I mean, and then there's of course the reformed ecclesiology would I think also we got to bring that to bear as well when we talk about incorporation, because if a church is incorporated as a not-for-profit, there are certain rights, legal rights, statutory rights that the membership would have vis-a-vis their overseeing board or the board of elders or the elders, and I think that raises theological or ecclesiological considerations where we believe that Christ is the head of the church. Under Christ is his delegated authority to the elders, and then the congregation is under the authority of the elders. Whereas an incorporated church through statute, the Ontario statute or the British Columbia statute, whatever, actually inverts that relationship a little bit in the sense that members have rights against their board of elders. And so things like, passing budgets or some of those things, it's the members who assert their authority over the elders. The elders take direction from the congregation. There's more nuance to it than that, I think, and there's other considerations involved in around that. But I wonder if that raises some red flags even from an ecclesiological perspective outside of the legal question.
Yeah, it might. I think it's important for churches to look at, because there are different legal options available, so to see where that kind of the church's legal personality, and churches do exist as legal entities,
right?
How well that fits, like you said, the ecclesiology of the church, and if it is an incorporated church, the question may be how is that corporation set up?
Yeah. So, any other impressions from this decision, John? Anything else that you'd want to share with the viewers?
I'm happy. I think it clears up if there was any gaps in wall, pun intended, I guess. But that this really patches those up in a way that I think is going to be helpful for churches in particular going forward. We'll see. It'll be interesting to see how. If and how this can be applied to other Christian organizations with internal religious rules. I think it applies most strongly to churches. That's probably why it's a 9-0. We noted that the Equality for Gays and Lesbians Everywhere group intervened and urged the court to not kind of recuse itself just because it's a religious setting or just because it's a religious organization. I think that line of argument may get more traction in cases where it's not a church, where there's more to it than where there's some kind of service being received, whether it's education or if someone actually works for the organization. Right. This is just a lay member, no payment, no legal interest, no proprietary interest. Right. And that way it's a bit simpler, but it'll be interesting to see how this might get applied in other cases. Yeah, and also for our viewers, that another exciting thing about this judgment is that of all of the interveners in this case, and there was a number of them, about a dozen or so, only 2, by my count, got cited, and one of those 2 was ARPA. So congratulations, John, that your work paid off again. That ARPA was cited in the judgment for a particular principle. That was exciting. I'm trying to remember which paragraph it was. So 42, I believe. Paragraph 42. Courts should not be too quick to characterize religious commitments as legally binding in the first place, as the intervener, the Association for Reform Political Action Canada, observed. So you're cited directly there. That's exciting as well. So all around, I just want to. Lately, good news in the political legal realm has been a bit hard to come by. Today was
really good news coming out of the Supreme Court of Canada. We're very, very thankful that a unanimous court has clarified that the secular government, particularly the courts, are not going to interfere with church decisions around membership and around doctrine, that is more or less the exclusive domain of an independent institution, that being the church. This is a strong reassertion of what we had already won in the Wall decision just a couple of years ago in 2018. So we can be really thankful for that. I think the practical implication is that, when we think about the church in Canada today in an increasingly hostile, I think, and increasingly secular environment, that this decision says the church is still free to exercise the keys of the kingdom, the preaching of the gospel, so regarding questions of doctrine as well, and the exercise of church discipline, including the use of expulsion if required. That's still recognized by a unanimous Supreme Court as the jurisdiction of the church, and we can be thankful for that. And may God bless then the ministry of the church across this country as it does preach the gospel, apply it, delve into the doctrines of the church and share those and apply those to the lives of their members and apply it to the life of this country, and then also to be able to use the keys of the kingdom as it relates to the use of sacraments and church discipline, that too for God's glory and the benefit of the church. We're really thankful for that. As well, I just want to say to you, our viewers, thank you so much for praying for this case. So this case arose, like we said, last year, January, February. We were already made aware of it. We asked for prayer then already through the whole appeal process, through our intervention process. We were asking for prayer. We asked for prayer for a blessing on John's arguments in December. We asked for a prayer over the Supreme Court of Canada, all 9 judges, that they would give serious consideration to the arguments made, not just by ARPA, but by all of the other lawyers involved on our side. And the Lord answered those prayers. Those prayers were coming around dinner tables, and they were coming off of pulpits. We know that. People have been telling us that. And thank the Lord and praise the Lord that he's answered it in a way that we were hoping for in a decision like this. So be encouraged this weekend. Also, as you go into a Pentecost weekend, as we celebrate the gift of the Holy Spirit, be encouraged that there is good news coming out of some of our higher institutions of power. Praise the Lord for that, and thank you again. Thank you to you, John, as well, for coming in and talking about the case and for your work on this case in particular. God bless you and your work as well.
Thank you. It's good to be here.
All right. Take care.